Welcome back, everybody, to our studies in public law. In this lesson, what we're going to do is talk about the idea of procedural impropriety. Now, this is also in consideration of the grounds for judicial review. We focused on this idea of irrationality. We talked about the concept of illegality, Wensbury and reasonableness. We talked a little bit about proportionality. This, like I said, is going to begin talking about the concept of procedural impropriety. This is considered to be the third ground for judicial review, which was cited by Lord Diplock. If you remember back to the case that we examined all the way at the beginning of this series of lessons on the concept of judicial review. So, as an introduction, the concept of procedural impropriety. What does the concept of procedural impropriety actually refer to? Well, essentially, it refers to circumstances and situations in which the executive body, the body or the local government or whatever that is under the particular scrutiny that we're applying judicial review to, has acted in a way which fails to observe various different procedural rules. So they're not necessarily acting in a way that is illegal. They're not acting in a way that is irrational necessarily or not proportional, but they are failing to observe some of the basic procedural rules that exist when it comes to the implementation of various different legislative considerations, the application of law, whatever kinds of policies that they're looking to implement. We can take these procedural rules that we're thinking about and sort of condense them into two basic principles. Because there are lots of different procedural rules, we're not referring to every single different type of procedural rule in every single different circumstance. The procedural rules that we are referring to generally fall into one of two categories. Failure to observe the procedural rules which are applied in statute. So obviously, a lot of local government or executive bodies have their authority derived from statute, and a lot of statute will apply or ensure that there is the application of various different procedural rules, and these would be enshrined within the statute itself. Alternatively, we can think about the failure to observe procedural rules which are laid down by the principle of natural justice. The principle of natural justice is a little bit more vague, a little bit more holistic, but it does come attached with it a number of important elements and important principles that we will get to in future lessons' time. But generally speaking, we can sort of distill, if you will, the idea of procedural rules into either rules relating to statute or rules relating to natural justice. So, in terms of looking at statute and failure to observe statutory rules, it can be said that a public body has acted ultra vires. It has acted beyond its authority, and therefore there is a legitimate ground and a legitimate case of judicial review in circumstances in which they have failed to comply with the prerequisite procedural requirements which are then laid down by a particular piece of legislation. So a legislation, like I said, will give the authority of an executive body to do and perform certain actions, to pass certain rules and regulations in certain circumstances. But a lot of these pieces of legislation will also have attached to it various different ways in which procedures ought to be followed in order to ensure that the law is actually being applied in a correct way. And so, given an example here, we can think about the case of the Agricultural, Horticultural and Forestry Industry Training Board versus Aylesbury Mushrooms. This is a case from 1972. If you were to write this case or to cite this case in an exam and you were handwriting an exam, you would probably be fine by just saying Aylesbury Mushrooms 1972. When there are very, very, very long cases that either will eat up your word count or it will take too long to write down in an exam. Just cite the respondents to these cases or the defendants in these cases, because then people will understand what you're referring to, and obviously cite the date as well. This case concerned the establishment of an industrial training board. This was under the executive branch, established under the executive branch by and under the remit of the Industrial Training Act of 1964. So the Industrial Training Act of 1964 is the legislation, is the parliamentary legislation that was passed that gives the executive branch certain authorities for the establishment of industrial trainings boards. And there are obviously different ways in which this ought to be done. There were procedures that had to be followed. When it comes to enabling legislation such as this, the creation of such a board would require consultation with the appropriate authorities on the part of the minister in question. So the minister that is authorized to be creating these training boards, so potentially the agriculture minister or potentially some other kind of minister of state, they would have to consult the appropriate authorities, the appropriate experts essentially, before creating such a board. This legislation was no different. In Section 1, Subsection 4, there was the requirement under the Industrial Trainings Act for the mandatory consultation with the relevant authorities. This is representative of the procedure that we're talking about, the procedural element of the legislation that we're referring to, such that if you do not act within this procedural element, you could be brought up on charges of procedural impropriety, essentially. The minister had therefore consulted with the National Farmers Union, but was not the subsidiary of the NFU, the Mushroom Growers Association. So we have a number of different problems here. So the question here is essentially: did the minister act ultra vires in creating the trainings board by only consulting the National Farmers Union and not consulting the Mushroom Growers Association, which was a subsidiary? Now, like we said here, the question of consultation was held to be mandatory. So the question of who should be consulted, however, was seen to be something which was dependent on the subjective belief of the minister. So what we have here is an example of the discretion that can be given to ministers in certain circumstances when it comes to their application of procedure. All that really is required is the mandatory consultation with the relevant authorities. Who actually counts as a relevant authority is a question that really lays a little bit to the minister, but of course, obviously can be considered within the context of the legislation as well by the courts, because if the minister consulted a completely different union or a completely different association, then of course this would represent something of a failure to consult with the, quote, relevant authorities. So the question of, like I said, the question of consultation was held to be mandatory, but the question of who should be consulted was seen as something which was therefore dependent on the subjective belief of the minister. And you also had to take into consideration what was meant by the word consultation. To what extent was a meeting, or what extent was a back and forth discussion a consultation? What counted as a consultation? So essentially, who was to be consulted in this circumstance, and what did it mean to consult in this circumstance? Well, the courts held that consultation meant a communication of genuine invitation with the view that there would be the granting of advice. So a consultation wouldn't be, for example, the minister meeting the National Farmers Union and telling them what is going to happen. That doesn't seriously represent something of a consultation, because it wasn't a communication of genuine invitation, and there wasn't the view that there would be the granting of advice from the Farmers Union. It was therefore held on account of the nature of the meeting that was had and the people who were met with in creating these training boards, that there had actually been no consultation. And so as a result of which, the minister had acted procedurally ultra vires and would have been found on this ground to have acted ultra vires on the basis of procedural impropriety.